Title 3, Penalties, Chapter 1, Penalties in General, Article 21, Penalties that may be imposed. No felony shall be punishable by any penalty not prescribed by law prior to its commission. Article 22, Retroactive Effect of Penal Laws. Penal laws shall have a retroactive effect insofar as they favor the person guilty of a felony, who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this Code. Although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. Article 23. Effect of pardon by the offended party. A pardon by the offended party does not extinguish criminal action except as provided in Article 344 of this Code, but civil liability with regard to the interest of the injured party is extinguished by his express waiver. Article 24. Measures of prevention or safety which are not considered penalties. The following shall not be considered as penalties. 1. The arrest and temporary detention of accused persons, as well as their detention by reason of insanity or imbecility, or illness requiring their confinement in a hospital. 2. The commitment of a minor to any of the institutions mentioned in Article 80 and for the purposes specified therein. 3. Suspension from the employment or public office during the trial or in order to institute proceedings. 4. Fines and other corrective measures which, in the exercise of their administrative or disciplinary powers, superior officials may impose upon their subordinates. 5. Deprivation of rights and the reparations which the civil laws may establish in penal form. Chapter 2. Classification of penalties. Article 25. Penalties which may be imposed. The penalties which may be imposed, according to this Code, and their different classes are those included in the following: Scale, principal penalties, capital punishment, death, afflictive penalties, reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, prisión mayor, correctional penalties, prisión correccional, arresto mayor, suspensión, destierro, light penalties, arresto menor, public censure, penalties common to the three preceding classes, fine, and bond to keep the peace. Accessory penalties, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, the right to vote and be voted for, the profession or calling, civil interdiction, indemnification, forfeiture or confiscation of instruments and proceeds of the offense, payment of cost. Article 26. Fine, when afflictive, correctional, or light penalty. A fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty if it exceeds 6,000 pesos, a correctional penalty if it does not exceed 6,000 pesos but is not less than 200 pesos, and a light penalty if it be less than 200 pesos. Chapter 3. Duration and Effect of Penalties. Section 1. Duration of Penalties. Article 27. Reclusion perpetua. Any person sentenced to any of the perpetual penalties shall be pardoned after undergoing the penalty for 30 years, unless such person, by reason of his conduct or some other serious cause, shall be considered by the chief executive as unworthy of pardon. Reclusion temporal. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. Prisión mayor and temporary disqualification. The duration of the penalties of prisión mayor and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Prisión correccional, suspensión, and destierro. The duration of the penalties of prisión correccional, suspensión, and destierro shall be from 6 months and 1 day to 6 years, except when suspension is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Arresto mayor. The duration of the penalty or arresto mayor shall be from 1 month and 1 day to 6 months. Arresto menor. The duration of the penalty of arresto menor shall be from 1 day to 30 days. Bond to keep the peace. The bond to keep the peace shall be required to cover such period of time as the court may determine. Article 28. Computation of penalties. If the offender shall be in prison, the term of the duration of the temporary penalties shall be computed from the day on which the judgment of conviction shall have become final. If the offender be not in prison, the term of the duration of the penalty, consisting of deprivation of liberty, shall be computed from the day that the offender is placed at the disposal of the judicial authorities for the enforcement of the penalty. The duration of the other penalties shall be computed only from the day on which the defendant commences to serve his sentence. Article 29. 1/2 of the period of the preventive imprisonment deducted from term of imprisonment. Offenders who have undergone preventive imprisonment shall be credited in the service of their sentence, consisting of deprivation of liberty, with 1/2 of the time during which they have undergone preventive imprisonment, except in the following cases. 1. When they are recidivist or have been convicted previously twice or more times of any crime. 2. When upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. 3. When they have been convicted of robbery, theft, estafa, malversation of public funds, falsification, vagrancy, or prostitution. Section 2. Effects of the penalties according to their respective nature. Article 30. Effects of the penalties of perpetual or temporary absolute disqualification. The penalties of perpetual or temporary absolute disqualification for public office shall produce the following effects. 1. The deprivation of the public offices and employments which the offender may have held, even if conferred by popular election. 2. The deprivation of the right to vote in any election for any popular elective office or to be elected to such office. 3. The disqualification for the offices or public employments and for the exercise of any of the rights mentioned. In case of temporary disqualification, such disqualification as is comprised in paragraphs 2 and 3 of this article shall last during the term of the sentence. 4. The loss of all right to retirement pay or other pension for any office formerly held. Article 31. Effects of the penalties of perpetual or temporary special disqualification. The penalties of perpetual or temporary special disqualification for public office, profession, or calling shall produce the following effects. 1. The deprivation of the office, employment, profession, or calling affected. 2. The disqualification for holding similar offices or employments, either perpetually or during the term of the sentence, according to the extent of such disqualification. Article 32. Effects of the penalties of perpetual or temporary special disqualification for the exercise of the right of suffrage. The perpetual or temporary special disqualification for the exercise of the right of suffrage shall deprive the offender perpetually or during the term of the sentence, according to the nature of said penalty, of the right to vote in any popular election for any public office or to be elected to such office. Moreover, the offender shall not be permitted to hold any public office during the period of his disqualification. Article 33. Effects of the penalties of suspension from any public office, profession, or calling, or the right of suffrage. The suspension from public office, profession, or calling, and the exercise of the right of suffrage shall disqualify the offender from holding such office or exercising such profession or calling or right of suffrage during the term of the sentence. The person suspended from holding public office shall not hold another having similar functions during the period of his suspension. Article 34. Civil interdiction. Civil interdiction shall deprive the offender, during the time of his sentence, of the rights of parental authority or guardianship, either as to the person or property of any ward, of marital authority, of the right to manage his property, and of the right to dispose of such property by any act or any conveyance inter vivos. Article 35. Effects of bond to keep the peace. It shall be the duty of any person sentenced to give bond to keep the peace, to present two sufficient sureties who shall undertake that such person will not commit the offense sought to be prevented, and that in case such offense be committed, they will pay the amount determined by the court in its judgment, or otherwise to deposit such amount in the office of the clerk of the court to guarantee said undertaking. The court shall determine, according to its discretion, the period of duration of the bond. Should the person sentenced fail to give the bond as required, he shall be detained for a period which shall in no case exceed 6 months, if he shall have been prosecuted for a grave or less grave felony, and shall not exceed 30 days if for a light felony. Article 36. Pardon. Its effects. A pardon shall not work the restoration of the right to hold public office or the right of suffrage unless such rights be expressly restored by the terms of the pardon. A pardon shall in no case exempt the culprit from the payment of the civil indemnity imposed upon him by the sentence. Article 37. Cost. What are included? Costs shall include fees and indemnities in the course of the judicial proceedings, whether they be fixed or unalterable amounts previously determined by law or regulations in force, or amounts not subject to schedule. Article 38. Pecuniary liabilities. Order of payment. In case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities, the same shall be met in the following order. 1. The reparation of the damage caused. 2. Indemnification of consequential damages. 3. The fine. 4. The cost of the proceedings. Article 39. Subsidiary penalty. If the convict has no property with which to meet the pecuniary liabilities mentioned in paragraph 1st, 2nd, and 3rd of the next preceding article, he shall be subject to a subsidiary personal liability at the rate of 1 day for each 2 pesos and 50 centavos, subject to the following rules. 1. If the principal penalty imposed be prisión correccional o arresto and fine, he shall remain under confinement until his fine and pecuniary liabilities referred in the preceding paragraph are satisfied, but his subsidiary imprisonment shall not exceed 1/3 of the term of the sentence, and in no case shall it continue for more than 1 year, and no fraction or part of a day shall be counted against the prisoner. 2. When the principal penalty imposed be only a fine, the subsidiary imprisonment shall not exceed 6 months, if the culprit shall have been prosecuted for a grave or less grave felony, and shall not exceed 15 days, if for a light felony. 3. When the principal penalty imposed is higher than prisión correccional, no subsidiary imprisonment shall be imposed upon the culprit. 4. If the principal penalty imposed is not to be executed by confinement in a penal institution, but such penalty is of fixed duration. The convict, during the period of time established in the preceding rules, shall continue to suffer the same deprivations as those of which the principal penalty consists. 5. The subsidiary personal liability which the convict may have suffered by reason of his insolvency shall not relieve him from reparation of the damage caused, nor from indemnification for the consequential damages in case his financial circumstances should improve, but he shall be relieved from pecuniary liability as to the fine. Section 3. Penalties in which other accessory penalties are inherent. Article 40. Death. Its accessory penalties. The death penalty, when it is not executed by reason of commutation or pardon, shall carry with it that of perpetual absolute disqualification and that of civil interdiction during 30 years following the date of sentence, unless such accessory penalties have been expressly remitted in the pardon. Article 41. Reclusion perpetua and reclusion temporal. Their accessory penalties. The penalties of reclusion perpetua and reclusion temporal shall carry with them that of civil interdiction for life, or during the period of the sentence as the case may be, and that of perpetual absolute disqualification, which the offender shall suffer even though pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 42. Prision mayor. Its accessory penalties. The penalty of prision mayor shall carry with it that of temporary absolute disqualification, and that of perpetual special disqualification from the right of suffrage, which the offender shall suffer, although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 43. Prision correccional. Its accessory penalties. The penalty of prision correccional shall carry with it that of suspension from public office, from the right to follow a profession or calling, and that of perpetual special disqualification from the right of suffrage, if the duration of said imprisonment shall exceed 18 months. The offender shall suffer the disqualification provided in this article, although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 44. Arresto. Its accessory penalties. The penalty of arresto shall carry with it that of suspension of the right to hold office and the right of suffrage during the term of the sentence. Article 45. Confiscation and forfeiture of the proceeds or instruments of the crime. Every penalty imposed for the commission of a felony shall carry with it the forfeiture of the proceeds of the crime and the instruments or tools with which it was committed. Such proceeds and instruments or tools shall be confiscated and forfeited in favor of the government, unless they be the property of a third person not liable for the offense, but those articles which are not subject of lawful commerce shall be destroyed. Chapter 4. Application of penalties. Section 1. Rules for the application of penalties to the persons criminally liable and for the graduation of the same. Article 46. Penalty to be imposed upon principals in general. The penalty prescribed by law for the commission of a felony shall be imposed upon the principals in the commission of such felony. Whenever the law prescribes a penalty for a felony in general terms, it shall be understood as applicable to the consummated felony. Article 47. In what cases the death penalty shall not be imposed. The death penalty shall be imposed in all cases in which it must be imposed under existing laws, except in the following cases. 1. When the guilty person be more than 70 years of age. 2. When upon appeal or revision of the case by the Supreme Court, all the members thereof are not unanimous in their voting as to the propriety of the imposition of the death penalty. For the imposition of said penalty or for the confirmation of a judgment of the inferior court, imposing the death sentence, the Supreme Court shall render its decision per curiam, which shall be signed by all justices of said court, unless some member or members thereof shall have become disqualified from taking part in the consideration of the case, in which event the unanimous vote and signature of only the remaining justices shall be required. Article 48. Penalty for complex crimes. When a single act constitutes two or more crimes, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Article 49. Penalty to be imposed upon the principals when the crime committed is different from that intended. In cases in which the felony committed is different from that which the offender intended to commit, the following rules shall be observed. 1. If the penalty prescribed for the felony committed be higher than that corresponding to the offense which the accused intended to commit, the penalty corresponding to the latter shall be imposed in its maximum period. 2. If the penalty prescribed for the felony committed be lower than that corresponding to the one which the accused intended to commit, the penalty for the former shall be imposed in its maximum period. The rule established by the next preceding paragraph shall not be applicable if the acts committed by the guilty person shall also constitute an attempt or frustration of another crime, if the law prescribes a higher penalty for either of the latter offenses, in which case the penalty provided for the attempt or the frustrated crime shall be imposed in its maximum period. Article 50. Penalty to be imposed upon principals of a frustrated crime. The penalty next lower in degree than that prescribed by law for the consummated felony shall be imposed upon the principal in a frustrated felony. Article 51. Penalty to be imposed upon principals of attempted crimes. The penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the principals in an attempt to commit a felony. Article 52. Penalty to be imposed upon accomplices in a consummated crime. The penalty next lower in degree than that prescribed by law for the consummated felony shall be imposed upon the accomplices in the commission of a consummated felony. Article 53. Penalty to be imposed upon accessories to the commission of a consummated felony. The penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the accessories to the commission of a consummated felony. Article 54. Penalty to be imposed upon accomplices in a frustrated crime. The penalty next lower in degree than that prescribed by law for the frustrated felony shall be imposed upon the accomplices in the commission of a frustrated felony. Article 55. Penalty to be imposed upon accessories of a frustrated crime. The penalty lower by 2 degrees than that prescribed by law for the frustrated felony shall be imposed upon the accessories to the commission of a frustrated felony. Article 56. Penalty to be imposed upon accomplices in an attempted crime. The penalty next lower in degree than that prescribed by law for an attempt to commit a felony shall be imposed upon the accomplices in an attempt to commit the felony. Article 57. Penalty to be imposed upon accessories of an attempted crime. The penalty lower by 2 degrees than that prescribed by law for the attempt shall be imposed upon the accessories to the attempt to commit a felony. Article 58. Additional penalty to be imposed upon certain accessories. Those accessories falling within the terms of paragraph 3 of Article 19 of this Code who should act with abuse of their public functions shall suffer the additional penalty or absolute perpetual disqualification if the principal offender shall be guilty of a grave felony, and that of absolute temporary disqualification if he shall be guilty of a less grave felony. Article 59. Penalty to be imposed in case of failure to commit the crime because the means employed or the aims sought are impossible. when the person intending to commit an offense has already performed the acts for the execution of the same, but nevertheless the crime was not produced by reason of the fact that the act intended was by its nature one of impossible accomplishment, or because the means employed by such person are essentially inadequate to produce the result desired by him, the court, having in mind the social danger and the degree of criminality shown by the offender, shall impose upon him the penalty of arresto mayor, or a fine ranging from 200 to 500 pesos. Article 60. Exceptions to the rules established in Articles 50 to 57. The provisions contained in Articles 50 to 57, inclusive of this code, shall not be applicable to cases in which the law expressly prescribes the penalty provided for a frustrated or attempted felony, or to be imposed upon accomplices or accessories. Article 61. Rules for graduating penalties. For the purpose of graduating the penalties which, according to the provisions of Articles 50 to 57, inclusive of this code, are to be imposed upon persons guilty as principals of any frustrated or attempted felony, or as accomplices or accessories, the following rules shall be observed. 1. When the penalty prescribed for the felony is single and indivisible, the penalty next lower in degree shall be that immediately following that indivisible penalty in the scale prescribed in Article 70 of this code. 2. When the penalty prescribed for the crime is composed of two indivisible penalties, or of one or more divisible penalties to be imposed to their full extent, the penalty next lower in degree shall be that immediately following the lesser of the penalties prescribed in the above-mentioned scale. 3. When the penalty prescribed for the crime is composed of one or two indivisible penalties, and the maximum period of another divisible penalty, the penalty next lower in degree shall be composed of the medium and minimum periods of the proper divisible penalty, and the maximum period of that immediately following in said scale. 4. When the penalty prescribed for the crime is composed of several periods corresponding to different divisible penalties, the penalty next lower in degree shall be composed of the period immediately following the minimum prescribed and of the two next following, which shall be taken from the penalty prescribed, if possible, otherwise from the penalty immediately following in the above-mentioned scale. 5. When the law prescribes a penalty for a crime in some manner not specially provided for in the four preceding rules, the courts, proceeding by analogy, shall impose corresponding penalties upon those guilty as principals of the frustrated felony or attempt to commit the same, and upon accomplices and accessories. For the tabulation of the provisions of the chapter, please refer on the screen. Section 2. Rules for the application of penalties with regard to the mitigating and aggravating circumstances and habitual delinquency. Article 62. Effects of the attendance of mitigating or aggravating circumstances and of habitual delinquency. Mitigating or aggravating circumstances and habitual delinquency shall be taken into account for the purpose of diminishing or increasing the penalty in conformity with the following rules. 1. Aggravating circumstances which in themselves constitute a crime specially punishable by law or which are included by the law in defining a crime, and prescribing the penalty therefore shall not be taken into account for the purpose of increasing the penalty. 2. The same rule shall apply with respect to any aggravating circumstances inherent in the crime to such a degree that it must of necessity accompany the commission thereof. 3. Aggravating or mitigating circumstances which arise from the moral attributes of the offender, or from his private relations with the offended party, or from any other personal cause, shall only serve to aggravate or mitigate the liability of the principals, accomplices, and accessories as to whom such circumstances are attendant. 4. The circumstances which consist in the material execution of the act, or in the means employed to accomplish it, shall serve to aggravate or mitigate the liability of those persons only who had knowledge of them at the time of the execution of the act or their cooperation therein. 5. Habitual delinquency shall have the following effects. A. Upon a third conviction, the culprit shall be sentenced to the penalty provided by law for the last crime of which he be found guilty, and to the additional penalty of prisión correccional in its medium and maximum periods. B. Upon a fourth conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he be found guilty, and to the additional penalty of prisión mayor in its minimum and medium periods. And C. Upon a fifth or additional conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he be found guilty, and to the additional penalty of prisión mayor in its maximum period to reclusión temporal in its minimum period. Notwithstanding the provisions of this article, the total of the two penalties to be imposed upon the offender, in conformity herewith, shall in no case exceed 30 years. For the purpose of this article, a person shall be deemed to be habitual delinquent if within a period of 10 years from the date of his release or last conviction of the crimes robo, hurto, estafa, or falsificación, he is found guilty of any of said crimes a third time or oftener. Article 63. Rules for the application of indivisible penalties. In all cases in which the law prescribes a single indivisible penalty, it shall be applied by the courts regardless of any mitigating or aggravating circumstances that may have attended to the commission of the deed. In all cases in which the law prescribes a penalty composed of two indivisible penalties, the following rules shall be observed in the application thereof. 1. When in the commission of the deed there is present only one aggravating circumstance, the greater penalty shall be applied. 2. When there are neither mitigating nor aggravating circumstances in the commission of the deed, the lesser penalty shall be applied. 3. When the commission of the act is intended by some mitigating circumstance and there is no aggravating circumstance, the lesser penalty shall be applied. 4. When both mitigating and aggravating circumstances attended the commission of the act, the courts shall reasonably allow them to offset one another in consideration of their number and importance, for the purpose of applying the penalty in accordance with the preceding rules, according to the result of such compensation. Article 64. Rules for the application of penalties which contain 3 periods. In cases in which the penalties prescribed by law contain 3 periods, whether it be a single divisible penalty or composed of 3 different penalties, each one of which forms a period in accordance with the provisions of Articles 76 and 77, the courts shall observe for the application of the penalty the following rules, according to whether there are or are not mitigating or aggravating circumstances. 1. When there are neither aggravating nor mitigating circumstances, they shall impose the penalty prescribed by law in its medium period. 2. When only a mitigating circumstance is present in the commission of the act, they shall impose the penalty in its minimum period. 3. When only an aggravating circumstance is present in the commission of the act, they shall impose the penalty in its maximum period. 4. When both mitigating and aggravating circumstances are present, the court shall reasonably offset those of one class against the other according to their relative weight. 5. When there are 2 or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law, in the period that it may deem applicable according to the number and nature of such circumstances. 6. Whatever may be the number and nature of the aggravating circumstances, the courts shall not impose a greater penalty than that prescribed by law in its maximum period. 7. Within the limits of each period, The courts shall determine the extent of the penalty according to the number and nature of the aggravating and mitigating circumstances and the greater or lesser extent of the evil produced by the crime. Article 65. Rule in cases in which the penalty is not composed of 3 periods. In cases in which the penalty prescribed by law is not composed of 3 periods, the courts shall apply the rules contained in the foregoing articles, dividing into 3 equal portions the time included in the penalty prescribed and forming 1 period of each of the 3 portions. Article 66. Imposition of fines. In imposing fines, the courts may fix any amount within the limits established by law. In fixing the amount in each case, attention shall be given, not only to the mitigating and aggravating circumstances, but more particularly to the wealth or means of the culprit. Article 67. Penalty to be imposed when not all the requisites of exemption of the 4th circumstance of Article 12 are present. When all the conditions required in circumstance number 4 of Article 12 of this Code to exempt from criminal liability are not present, the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period shall be imposed upon the culprit if he shall have been guilty of a grave felony, and arresto mayor in its minimum and medium periods if of a less grave felony. Article 68. Penalty to be imposed upon a person under 18 years of age. When the offender is a minor under 18 years, and his case is one coming under the provisions of the paragraph next to the last of Article 80 of this Code, the following rules shall be observed. 1. Upon a person under 15 but over 9 years of age, who is not exempted from liability by reason of the court having declared that he acted with discernment, a discretionary penalty shall be imposed, but always lower by 2 degrees at least than that prescribed by law for the crime which he committed. 2. Upon a person over 15 and under 18 years of age, the penalty next lower than that prescribed by law shall be imposed, but always in the proper period. Article 69. Penalty to be imposed when the crime committed is not wholly excusable. A penalty lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason of the lack of some of the conditions required to justify the same, or to exempt from criminal liability in the several cases mentioned in Articles 11 and 12, provided that the majority of such conditions be present. The courts shall impose the penalty in the period which may be deemed proper, in view of the number and nature of the conditions of exemption present or lacking. Article 70. Successive service of sentences. Exception. When the culprit has to serve 2 or more penalties, he shall serve them simultaneously if the nature of the penalties will so permit. Otherwise, said penalties shall be executed successively, following the order of their respective severity, which shall be determined in accordance with the following scale. 1. Death. 2. Reclusión perpetua. 3. Reclusión temporal. 4. Prisión mayor. 5. Prisión correccional. 6. Arresto mayor. 7. Arresto menor. A person sentenced to destierro who is also sentenced to the penalty of prisión or arresto shall be required to serve these latter penalties before serving the penalty of destierro. Article 71. Fine. The fine shall be considered as the last of all the principal penalties listed in the preceding article. When a fine is so imposed, the duration of the subsidiary liability corresponding thereto, by reason of the insolvency of the offender, shall not exceed that which is provided in Rule 2 of Article 39. Article 72. Preference in the payment of the civil liabilities. The civil liabilities of a person found guilty of 2 or more offenses shall be satisfied by following the chronological order of the dates of the final judgment rendered against him, beginning with the first in order of time. Section 3. Provision common to the last 2 preceding sections. Article 73. Presumption in regard to the imposition of accessory penalties. Whenever the courts shall impose a penalty which, by provision of law, carries with it other penalties according to the provisions of Articles 40, 41, 42, 43, 44, and 45 of this code, it must be understood that the accessory penalties are also imposed upon the convict. Article 74. Penalty higher than reclusion perpetua in certain cases. In cases in which the law prescribes a penalty higher than another given penalty without specifically designating the name of the former, if such higher penalty should be that of death, the same penalty and the accessory penalties of Article 40 shall be considered as the next higher penalty. Article 75. Increasing or reducing the penalty of fine by 1 or more degrees. Whenever it may be necessary to increase or reduce the penalty of fine by 1 or more degrees, it shall be increased or reduced, respectively, for each degree, by 1/4 of the maximum amount prescribed by law, without, however, changing the minimum. The same rules shall be observed with regard to fines that do not consist of a fixed amount but are made proportional. Article 76. Legal period of duration of divisible penalties. The legal period of duration of divisible penalties shall be considered as divided into 3 parts, forming 3 periods, the minimum, the medium, and the maximum in the manner shown in the following table. Please refer on the screen for the table showing the duration of divisible penalties and the time included in each of their periods. Article 77. When the penalty is a complex one composed of 3 distinct penalties. In cases in which the law prescribes a penalty composed of 3 distinct penalties, each one shall form a period. The lightest of them shall be the minimum, the next the medium, and the most severe the maximum period. Whenever the penalty prescribed does not have one of the forms especially provided for in this book, the periods shall be distributed, applying by analogy the prescribed rules. Chapter 5. Execution and Service of Penalties. Section 1. General Provisions. Article 78. When and how a penalty is to be executed. No penalty shall be executed except by virtue of a final judgment. A penalty shall not be executed in any other form than that prescribed by law, nor with any other circumstances or incidents than those expressly authorized thereby. In addition to the provisions of the law, the special regulations prescribed for the government of the institutions in which the penalties are to be suffered shall be observed with regard to the character of the work to be performed, the time of its performance, and other incidents connected therewith, the relations of the convicts among themselves and other persons, the relief which they may receive, and their diet. The regulations shall make provision for the separation of the sexes in different institutions, or at least into different departments, and also for the correction and reform of the convicts. Article 79. Suspension of the execution and service of the penalties in case of insanity. When a convict shall become insane or an imbecile after final sentence has been pronounced, the execution of said sentence shall be suspended only with regard to the personal penalty, the provisions of the second paragraph of circumstance number 1 of Article 12 being observed in the corresponding cases. If at any time the convict shall recover his reason, his sentence shall be executed, unless the penalty shall have prescribed in accordance with the provisions of this code. The respective provisions of this section shall also be observed if the insanity or imbecility occurs while the convict is serving his sentence. Article 80. Suspension of sentence of minor delinquents. Whenever a minor under 18 years of age, of either sex, be accused of a crime, the court, after hearing the evidence in the proper proceedings, instead of pronouncing judgment, shall suspend all further proceedings, and shall commit such minor to the custody or care of a public or private, benevolent or charitable institution established under the law for the care, correction, or education of orphaned, homeless, defective, and delinquent children, or to the custody or care of any other responsible person in any other place subject to visitation and supervision by the Public Welfare Commissioner or any of his agents or representatives, if there be any, or otherwise by the Superintendent of Public Schools or his representatives, subject to such conditions as are prescribed herein below, until such minor shall have reached his majority, or for such less period as the court may deem proper. The court, in committing said minor as provided above, shall take into consideration the religion of such minor, his parents or next of kin, in order to avoid his commitment to any private institution not under the control and supervision of the religious sect or denomination to which they belong. The Public Welfare Commissioner or his duly authorized representatives or agents, the Superintendent of Public Schools or his representatives, or the person to whose custody or care the minor has been committed, shall submit to the court every 2 months or as often as required a written report on the good or bad conduct of said minor and the moral and intellectual progress made by him. The suspension of the proceedings against a minor may be extended or shortened by the court on the recommendation of the Public Welfare Commissioner or his authorized representatives or agents, or the Superintendent of Public Schools or his representatives, according as to whether the conduct of such minor has been good or not, and whether he has complied with the conditions imposed upon him. The provisions of the first paragraph of this article shall not, however, be affected by those contained herein. If the minor has been committed to the custody or care of any of the institutions mentioned in the first paragraph of this article, with the approval of the Public Welfare Commissioner and subject to such conditions as this official in accordance with the law may deem proper to impose, such minor may be allowed to stay elsewhere under the care of a responsible person. If the minor has behaved properly and has complied with the conditions imposed upon him during his confinement, in accordance with the provisions of this article, he shall be returned to the court in order that the same may order his final release. In case the minor fails to behave properly or to comply with the regulations of the institution to which he has been committed or with the conditions imposed upon him when he was committed to the care of a responsible person, or in case he should be found incorrigible or his continued stay in such institution should be inadvisable, he shall be returned to the court in order that the same may render the judgment corresponding to the crime committed by him. The expenses for the maintenance of a minor delinquent confined in the institution to which he has been committed shall be borne totally or partially by his parents or relatives or those persons liable to support him, if they are able to do so, in the discretion of the court. Section 2. Execution of Principal Penalties. Article 81. When and how the death penalty is to be executed. The death sentence shall be executed with preference to any other and shall consist in putting the person under sentence to death by electrocution. The death sentence shall be executed under the authority of the Director of Prisons, endeavoring so far as possible to mitigate the sufferings of the persons under sentence during electrocution, as well as during the proceedings prior to the execution. If the person under sentence so desires, he shall be anesthetized at the moment of the electrocution. Article 82. Notification and execution of the sentence and assistance to the culprit. The court shall designate a working day for the execution, but not the hour thereof, and such designation shall not be communicated to the offender before sunrise of said day, and the execution shall not take place until after the expiration of at least 8 hours following the notification, but before sunset. During the interval between the notification and the execution, the culprit shall, in so far as possible, be furnished such assistance as he may request in order to be attended in his last moments by priests or ministers of the religion he professes, and to consult lawyers, as well as in order to make a will and confer with members of his family or persons in charge of the management of his business, of the administration of his property, or of the care of his descendants. Article 83. Suspension of the execution of the death sentence. The death sentence shall not be inflicted upon a woman within the 3 years next following the date of the sentence or while she is pregnant, nor upon any person over 70 years of age. In this last case, the death sentence shall be commuted to the penalty of reclusion perpetua, with the accessory penalty provided in Article 40. Article 84. Place of execution and persons who may witness the same. The execution shall take place in the penitentiary of Bilibid in a space close to the public view, and shall be witnessed only by the priest assisting the offender, and by his lawyers, and by his relatives, not exceeding 6, if he so request, by the physician and the necessary personnel of the penal establishment, and by such persons as the director of prisons may authorize. Article 85. Provision relative to the corpse of the person executed in its burial. Unless claimed by his family, the corpse of the culprit shall, upon the completion of the legal proceedings subsequent to the execution, be turned over to the Institute of Learning or Scientific Research first applying for it, for the purpose of study and investigation, provided that such institute shall take charge of the decent burial of the remains. Otherwise, the Director of Prisons shall order the burial of the body of the culprit at government expense, granting permission to be present thereat to the members of the family of the culprit and the friends of the latter. In no case shall the burial of the body of a person sentenced to death be held with pomp. Article 86. Reclusion perpetua, reclusion temporal, prision mayor, prision correccional, and arresto mayor. The penalties of reclusion perpetua, reclusion temporal, prision mayor, prision correccional, and arresto mayor shall be executed and served in the places and penal establishments provided by the administrative code in force or which may be provided by law in the future. Article 87. Destierro. Any person sentenced to destierro shall not be permitted to enter the place or places designated in the sentence, nor within the radius therein specified, which shall be not more than 250 and not less than 25 kilometers from the place designated. Article 88. Arresto menor. The penalty of arresto menor shall be served in the municipal jail or in the house of the defendant himself under the surveillance of an officer of the law, when the court so provides in its decision, taking into consideration the health of the offender and other reasons which may seem satisfactory to it. We hope you have enjoyed listening. More audiobooks are coming your way. Please support by clicking the subscribe button and bell icon to receive notifications of our latest upload. A like and share is appreciated. Audio and performance copyright by RAK Audio, all rights reserved.